Hello friends, in this video we're going to discuss about the latest amendments which have been proposed by the 55th GST Council meeting held on 21st of December at Jaisalmer. The first and foremost is with regard to the IMS getting legal backing. Now IMS, we all know, very recently has been made optional by the government and it has been provided on the portal that for each invoice I can make an accept, reject or pending action. Now, as of now, this measure is optional and it does not have any legal backing. In the future, it has been provided that IMS will get its adequate legal backing through amendment in the relevant provisions of the law. So, GSTR 2B would get regenerated once the IMS actions are taken. So, legal framework for regeneration of 2B based on IMS actions. Also, if I am the supplier, you are the recipient. If I, as the supplier, I am issuing any credit note and you have not reversed your ITC, in such cases, my output tax would not be allowed to be reduced. So my output tax reduction would depend on your input tax reduction also. So this, as of now, is not a measure provided under the law under section 34. This is only provided in respect of discount, post-discount credit notes, but this would be applicable in the future for all credit notes. And also, manner in which output can be adjusted. That means there would be a procedure. It would not be a simple measure that I issue a credit note and I can reduce my output. There would be a complete procedure that would be prescribed as to how my output tax would be reduced as long as my ITC is reduced for the recipient. Also, 2B is a very important form which is now going to perhaps get even more important given that it would get regenerated based on IMS. So GSTR 3B would not be allowed to be filed even if there is no ITC, because now it has been said only after 2B generation 3B would be allowed to be filed. Now, one of the most relevant amendments which is just proposed is with regard to amendment in section 17(5)(d). So we all know the judgment with regard to safari retreats, which provided with the concept of the plant or machinery, which says that ITC would be available only in respect of plant or machinery. The term used, which is plant and machinery, which is defined in the law, would not be applicable and would not have the same meaning as plant or machinery. As a result of it, a lot of relevance was put by this judgment on functionality test, object of construction. That means if I am constructing a property with the objective of renting it out and it is fulfilling certain specialized objectives while the construction was happening. So all of that was assuming a prime importance, because if I was assuming the term plant or machinery, I could get ITC, which was not otherwise available on plant and machinery. So these tests assumed a lot of importance on case-to-case basis, as a result of which this judgment had a lot of importance in terms of making sure people get ITC, which was otherwise not available to them. Now, in order to put to rest such disputes, the government aims to make a retrospective amendment in the law by substituting the term of plant or machinery to plant and machinery. So now, after this substitution, their aim is to not allow any ITC on any building which is being constructed, even though the idea is to rent it out. Having said this, how far this particular retrospective amendment will hold good is something which is yet to be seen. We have seen Supreme Court judgments of Vatika townships and other judgments where it has been mentioned that any amendment which is regressive to the assessee cannot be retrospective. So how far this would have a retrospective application is yet to be seen. But this is something which the government aims to, as they call it, an anomaly which they want to correct. So let's see how far this would hold good. Next is pre-deposit. Now for detention matters under section 129, the pre-deposit is 25% of the disputed penalty. It has been proposed that this 25% would be reduced to 10% of penalty, and at the appellate tribunal level it would be reduced to, it would be notified at further 10% of penalty. So it would be basically 20% of the penalty for appearing before the tribunal in respect of pre-deposit, and the first level it would be 10%. As of now, at the first level itself, it was 25%. Also, if I am supplying goods from SEZ within SEZ itself, there was no clarity with regard to taxability of such kind of items. So here it has been provided that it would be neither treated as supply of goods nor supply of services. So, but if SEZ is supplying to DTA, that is outside the SEZ territory, obviously it would be taxable. While clearance of these goods, it would be paid. For export, it would be zero rated supply. But within SEZ to SEZ, as of now, it has been provided, it would be neither a supply of goods nor supply of services. Next, interstate RCM for ISD transactions. Now, ISD for the first time is becoming mandatory from 1st April 2025. Also, it had been provided that RCM transaction would also allowed to be distributed as ITC through the ISD mechanism. It has now been provided that interstate transactions for RCM would also be introduced, and there would be an explicit provision which would allow payment of IGST in case of interstate transactions for ISD mechanism. Next is the track and trace mechanism, which is again a very unique sort of measure which they are trying to adopt in order to catch tax evasion. So they are wanting to insert a new provision to enforce track and trace mechanism for specified evasion prone commodities. So there would be certain commodities for which this mechanism would become compulsory. So they are saying that on the relevant product there would be a unique marking either on the goods itself or on the packaging. From this unique marking, one would be able to trace them through the supply chain as to from whom and where these goods had been bought. So how far and how they are going to implement this mechanism is something which we are yet to see, because this is completely new, which we have not heard of. So idea is that every person who is buying the goods may be able to track that from whom and where these goods have been obtained through the entire supply chain. How far they would be required to do so and it would be mandatory for them is something which has to be seen. Whether the government would be using it to catch tax evasion and how they would be using it for catching tax evasion is something that is again yet to be seen. But this is again something which may be transformative, like the policy of e-invoicing and e-waybill which had been brought in earlier. Next is with regard to taxability of vouchers. Now, let's say I am using Amazon gift vouchers to buy any product. Now, Amazon gift voucher per se is not taxable. The underlying product may be taxable. So it has been said the voucher itself, the selling of vouchers itself is not taxable. Even if I am selling an Amazon gift voucher from one person to the other. So I am selling or distributing gift voucher from one person to the other on principal to principal basis. It would not be taxable. But if certain agents are appointed for selling those vouchers and those agents are earning commission out of it, in such cases on the commission element the tax would be levied. Also, for selling vouchers, if there are any ancillary services like advertisement, marketing promotion, customer support, anything of this sort is provided which is not directly from selling of these vouchers, that would also be leviable to GST. Now, let us say I buy a gift voucher. Now, that gift voucher had a validity of 1 year. I do not exercise my option of buying anything through that gift voucher. The question comes in, the amount earned by the selling company who had sold those gift vouchers or the issuing company, whether GST would be leviable on that? The answer is obviously a big no. This is similar to the concept of the European VAT, wherein the single purpose voucher and multi-purpose voucher has been written. So a similar concept has been adopted under the GST law. So obviously there would be substantial changes in the time of supply and the valuation provisions we are expecting after this particular provision is notified. So we are yet to see how this pans out in terms. Next is ITC on goods delivered at supplier's location. Normally, if I am selling goods to the supplier and the supplier, you are the recipient. Now, either I am giving the goods to you and you are collecting the goods from my premises, or you are sending your transporter to collect goods from my premises. That means when it comes to X works contract, on my doorstep, on my supplier's doorstep, the property in the goods gets transferred to the recipient. Either through the transporter or through the recipient himself, he would take the ownership of those goods at the doorstep of the supplier. In such cases, it would be deemed that the goods had been received by the recipient at that time itself. So even if he supplies the goods somewhere else, he sells those goods somewhere else, but it would be deemed to have been received by the recipient. So let's say I am located in West Bengal, the recipient is located in Karnataka, but he's selling the goods in West Bengal. Even if he takes the delivery of those goods at my doorstep in West Bengal, it would be deemed that he has received the goods in Karnataka, even though he is selling in West Bengal. Next is the late fees on 9C and past waiver. So we all know late fees had been prescribed for GST and 9, but there had been no late fees for 9C. A lot of people had filed 9, but they did not file 9C. So it has been clarified that the late fees is both for 9 and 9C. So in the future, if 9 has been filed but 9C is not filed, the late fees would still be applicable only. But for the past period when this was not clear, what they have mentioned is if I have filed my 9, but I have not filed my 9C, if I file my 9C within 31st March 25, my late fees would not be more than what I have paid for 9. So late fees of 9 itself would be applicable till 31st March 25. Obviously, if I have not filed 9 c does not mean that I get the complete waiver. On the 9, whatever late fees is there, that would be payable, right? So 9 late fees would still be payable. 9C late fees especially would not be payable if I'm filing within 31st March 25. Next is address on record for online services. So if I am buying any services online, let's say I am buying a movie from Netflix and it is being supplied to unregistered recipients. So I am a person who is unregistered. Then the supplier who is supplying those services online needs to mandatorily record the name of the recipient on the tax invoice. So any online gaming services, any website you play online games or you watch online movies or take any services online, the recipient's name should be recorded by the supplier in the invoice issued by them, so that the tax goes to the relevant state and the state whose name is recorded would be deemed to be the address on record. Next, proportionate reversal not required on 9(5) services. So when we consider e-commerce operators, let's say we talk about Zomato and Swiggy. Now they are paying taxes for all the restaurant services also on behalf of the restaurant. So given that they are paying taxes on behalf of the restaurant and not on their own accord for their own income, so question comes in for the supplies made on behalf of the restaurant and the tax paid on behalf of the restaurant. Would they be required to carry out proportionate ITC reversal? The answer is no. It has been clarified that ITC reversal would not be carried out for such cases. Last, a few relevant amendments and clarifications which perhaps are settling a lot of disputes. One is ACC blocks. Now ACC blocks per se was not defined under law. Department used to tax it at 18%. We used to say it would be taxable at 5%, thereafter revised to 12%. Because fly ash blocks and bricks were defined. But when it comes to ACC, it was not defined. So now for ACC blocks, they have said if the fly ash content is more than 50%, it would be considered as fly ash blocks, for which rate would be 12%. So this would put to rest a lot of disputes which are still pending before the department in terms of classification for ACC blocks. Also, for old and used vehicles, for smaller vehicles of less than 1200 cc and less than 4000 mm, the tax rate was 12% on sale of old vehicles. Now they are proposing to have tax rate of 18% on all old and used vehicles. Of course, it would be still on the margin, that is the selling price minus the WDV of the vehicle. Also, sponsorship services provided by the body corporate till now was under RCM. Now they are saying this would be in the future notified under forward charge mechanism. Next is with regard to composition taxpayers. Now composition taxpayers, we talk about small restaurants after the amendment of renting of commercial property under RCM. So once this was notified, it was a huge burden for small taxpayers who were paying taxes without availing ITC. For them to pay taxes on renting of commercial property, that was becoming a part of their cost. particularly smaller restaurants. So in such cases, they have mentioned a person who's having composition scheme, they may not be required to pay RCM on commercial property right from the beginning when it has been notified, that is 10th October 24. So this is something which they are wanting to make sure the burden on the composition taxpayers goes out. But for normal taxpayers also, I believe this is a huge burden, particularly the smaller taxpayers. So for them, this would still continue, the levy would still continue. We might see a few people now switching from normal to composition scheme in order to avoid this burden, particularly in the service industry where the renting is a huge part of their cost. Next is restaurant services. Now for restaurant services, it has been mentioned that if the declared tariff exceeded 7,500, in such cases the tax rate used to be 18%. Otherwise it used to be 5% without ITC. Now declared tariff was a very litigative concept because declared tariff was there under the luxury tax concept. As of now, most of the restaurants or hotels don't need to declare their tariff anywhere. So they are not notifying their tariff at any particular place. So what is declared tariff was becoming a huge amount of burden for the industry to define and understand. So in order to remove the concept of declared tariff completely, they have now said, if my value of supply in the preceding financial year is having more than 7,500 for any unit of the accommodation. So if my hotel has sold a single accommodation in the whole financial year last year for more than 7,500, any one accommodation, I would be liable to pay 18% on all my restaurant services with ITC. Also, in order to resolve this dispute for a few persons who may not be able to track such cases on a day-to-day basis as to which room has gone beyond 7,500, there's an option given to hotels that on the restaurants which they are running, they may charge 18% with ITC by giving a declaration at the beginning of the financial year that I want to go into the scheme of 18%. So now they have an option of going into 18% with ITC or 5% without ITC. This will be, I guess, a huge relief to a lot of restaurants which are having a lot of ITC blocked, particularly in case of hotels. And when the clarity is not there for declared tariff being more than 7,500, because there has been a lot of raids by DGGI, by investigation department of the state, where they have tried to tax those cases where 5% has been charged, though 18% should have been charged, and the concept of declared tariff is not clear. So with this, I come to the end of my session today. I thank each and every one for giving me a very patient hearing. Thank you.